Hello everyone and welcome to SEO's channel. I'm Sai Spandana and today I'm going to be talking about a case that's critical for the affirmation action discourse in our country. The case is State of Punjab versus Davinder Singh. Earlier this month, that is on the 8th of February 2024, a 7-judge constitution bench of the Supreme Court reserved judgment in the case. The central question in this case is, can a group within a reserved category of scheduled castes further be subclassified and granted reservations? Secondly, can states be allowed to identify who should be subclassified? For instance, in the present case, the state of Punjab had introduced 50% preferential reservations for Balmikis and Mazhabi Sikhs, two castes already covered under the scheduled caste lists in the state of Punjab. This meant that within the 25% reservation given to the scheduled castes in the state, 50% would be specifically reserved for the Balmikis and the Mazhabi Sikhs. Over 3 days of hearings, the petitioners argued for 2 days and the respondents for 1 day. What stood out in this case is that the union and several state governments that are typically opposing each other came together in support of subclassifications within the reserved categories. They argued that over the years, the court's jurisprudence had evolved to recognize that in society, there are more backward groups within the legally recognized backward groups. Now, why is the Supreme Court dealing with this case right now? The reason is that about 20 years ago, in E.V. Chinnaya versus State of Andhra Pradesh, the court had held that subclassification within the reserved categories was impermissible. They reasoned that scheduled castes formed a homogeneous group under the constitution. Later on in 2020, a 5-judge constitution bench in the state of Punjab versus Davinder Singh found that they could not agree with the reasoning in Chinnaya. As both the decisions were presided over by 5-judge benches, they referred the case to be decided once and for all by a larger 7-judge constitution bench. Finally, on 6th February 2024, a 7-judge bench commenced hearing the case. Chief Justice D.Y. Chandrachud led the bench, which also comprised Justices B.R. Gavai, Vikram Nath, Bela Trivedi, Pankaj Mittal, Manoj Mishra and S.C. Sharma. Now, what were the 5 core arguments on both sides during the course of the hearing? Watch along to find out. At the heart of this case is a very simple question. Are subclassifications necessary? The petitioners argued that subclassification was necessary as it ensures adequate representation of the most disadvantaged groups within the scheduled caste category. They said that it helped solve the issue of backwardness within backwardness. The respondents asserted that the reservation scheme of the constitution as it exists today sufficiently ensured that those who have been historically denied opportunity were adequately represented. So creating subclassifications within the reserved categories was not necessary. Now, back in 2004 in E.V. Chinnaya, the 5-judge bench had reasoned that scheduled castes as identified by the presidential list under Article 341 were a homogeneous group. Therefore, subclassification amongst them was not possible. The petitioners in the present case argued that the logic applied by the bench in Chinnaya was wrong. They said that while scheduled castes did share a history of discrimination, they were not a homogeneous group because each caste within the category faced various degrees of discrimination. There also existed a varying level of economical, social and educational development amongst each caste. The respondents submitted the opposite. Agreeing with the view in Chinnaya, they argued that while there may be differences amongst the castes within the scheduled caste list, they were still deemed to be a homogeneous group under the constitution because they were born together, that is, in the presidential list. They were all marked by the commonality of discrimination and backwardness, and so any differences that existed between them were eclipsed under the constitutional scheme. The key issue in this case is whether state governments can create subclassifications. In Chinnaya and in Davinder Singh, the governments of Andhra Pradesh and Punjab respectively had legislated laws creating quotas for certain castes within the scheduled caste groups for the state. The respondents argued that the presidential list, which has state-wise entries of scheduled castes, cannot be tampered with. Only the president could identify castes to be included in this list. If there was any inclusion or exclusion from the list, Only Parliament had the competence to make such changes. State governments would be consulted if necessary, but did not have the power to create subclassifications by themselves. The petitioners, however, claimed that the states could do so because they were in the best position to judge the backwardness of a community at a local level. They contended that subclassification did not involve creating or identifying new castes under the presidential list. That power remained with the president. They also said that the exercise of subclassification did not involve inclusion or exclusion from the list. That power remained with Parliament. What the states were doing was merely rationing the proportion of available resources to ensure that those who could not reap the benefits of reservations adequately could do so. Further, they submitted that under Article 16(4) of the Constitution, state included the union as well as state governments, and therefore the states could make laws to uplift those who were not adequately represented. By now it's pretty clear what the petitioners and respondents would have argued about this issue. On the correctness of Chinaya, the petitioners claim that the judgment in Chinaya was wrong, as it wrongly held that subclassification amounted to tinkering with the presidential list of scheduled castes. The respondents, of course, took the opposing view and supported the Chinaya judgment. Now we come to the last and perhaps the most important argument in this case. Now this argument is kind of tricky, so stay with me as I try to simplify it. So under Article 14, Subclause 4 of the Constitution, the state can make any provision for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services under the state. Now, the petitioners argued that if within the scheduled caste group, some castes were not adequately represented, then under Article 16, Subclause 4, those castes could be treated as backward classes and a provision for their upliftment could be made. The petitioners asserted that the phrase backward class was a term wide enough to include scheduled castes, scheduled tribes, and socially and economically backward classes. They relied on the majority opinion in Indira Sahni versus Union of India, a 9-judge bench decision from 1992, to assert that if certain castes were inadequately represented, they could be considered a backward class, and therefore the state could make provisions for their upliftment through subclassification. The respondents, on the other hand, argued that while with scheduled castes there was no doubt a presumption of backwardness, an individual caste could not be considered a class under Article 16, Subclause 4. Making laws for castes within the scheduled caste lists, they said, would amount to a violation of Article 16, Clause 2. Now, Article 16, Clause 2, of course, prohibits discrimination based solely on caste and other metrics such as religion, sex, race, place of birth, etc. The judgment in Indira Sahni, the respondent said, only applied to other backward classes, not scheduled castes and scheduled tribes. On the final day of hearings, Chief Justice D.Y. Chandrachud acknowledged the battle of backwardness within backwardness. However, he cautioned that authorities had to be careful. They could not leave out groups while granting benefits to the most backward sections. For this, he said that the court had the responsibility to tailor-make criteria for subclassifications. But when reservation remains a political touchpoint, how the Chief Justice's bench will draw these constitutional boundaries will be pivotal. This brings us to the end of this video. Thank you for watching. Do check out our detailed hearing reports on our cases page, and also look at our argument summary for a quick snapshot of the key arguments in the case. We've also compiled a list of 5 articles that you must read on the issue of subclassification. Do take a minute to read it. As always, stay tuned to SE Observer for more stories from the Supreme Court.